Funding is provided by a grant from New York State Senator Catherine M. Young, representing Western New York's 57th District with a local office in Olean. Funding is provided by a grant from Absolute Care of Westfield, committed to returning the favor to those who spent a lifetime caring for others. Absolute Care is located at 26 Cass Street in Westfield. Dave Cass and Rick Newell provide funding on behalf of the Lakeview Hotel and Restaurant at the docks, located on Water Street near the lake in Mayville. From the Access Channel 5 television studio in Mayville, it's Senior Report with Reed Powers. Join us live Saturday mornings between 9 and 10 a.m. in Fredonia, Mayville, and Silver Creek. Call in and share a thought or wish someone a happy birthday with Chautauqua County's only live on-air senior program. Reed continues in his 15th year with interesting guests expressing their viewpoints and informing the community on a variety of subjects. Here's the host of the show, Reed Powers.
Good morning. I don't mean to disappoint anybody, but obviously I'm not Reed. My name is Jim Subjack. You've probably seen me before, usually as a guest, but occasionally as a guest host. It's my honor to be here this morning for the vacationing Reed. I believe Reed is now on week 2 of his 3-week annual sojourn, and I hope he's having a good time. There's always the chance that Reed may call in, but don't take that as a guarantee. And as those of you that know lawyers know that lawyers usually don't guarantee a thing. I'm very honored today on behalf of this program to have as my guest the Honorable David Narducci, who's one of the town justices for the town of Chautauqua. And I expect we're going to have a lively, energetic program. The judge will give you some information regarding the criminal justice system, the court system, and you'll be surprised at actually what goes on. Everybody thinks that, for example, this is just a town court, it doesn't do much. You'd be surprised to know that there are a number of civil matters that go on always in town courts, and every criminal matter, with the exception of very few things which are presented directly to grand jury, have to go through the local courts. So this judge has been judge for a long time. He's very well experienced, he's very well trained, he's very well educated, he's very fair, and he's going to give you his perspective of the way the court systems work and what we need to do. There'll be some things we talk about, for example, the new Leanders Law that has come into effect, the second part of it having come into effect this past August, which has some severe consequences for those who drink and drive. But now, before we go with Justice Narducci, as always, it's my honor and my pleasure to introduce to you, I'm not going to call him that pejorative term that Reed always calls him. I'm going to call him my friend, Mort Flexer. Mort?
Thank you, Jim. Your Honor, welcome.
Oh, thank you.
And ladies and gentlemen, welcome. If I seem a little punchy this morning, I am. About 4 o'clock, and this is a constant weekend problem, the train comes blasting through Westfield with a horn just going away, wild. Why? I don't know. How they get away with it? I don't know. I know I get evil thoughts. I think seriously about shooting an engineer or hiring somebody to do it. But honest, Jim, I will not take that step.
Yeah, see, that's not even privileged. Lawyer-client privilege only extends to those things that have happened in the past as opposed to future criminal acts, so I'd have to turn you in.
Well, perhaps you two can go through a re-examination of the law and see why it is legal for somebody to come through and ruin the health of so many people in so many communities along the line. I can't believe that Westfield is the only one. As a matter of fact, I don't know why the heck they blasted in Westfield. All of the crossings are protected. So anyway, it is frustrating as you know what. And I'll try next week. I'll do my darndest to be awake and say something that makes some sense. Thank you.
Mort, actually, that made a lot of sense, and I'm sure a lot of people share your sentiments and your sympathies. Now, they're actually, in the city of Dunkirk, they convinced the freight lines to not blow the whistle, but Dunkirk had to assume the liability, and that really is a liability issue. People get killed even with the gate crossings down, and that's supposedly to warn, and they're actually required by law to do that. But in any event, again, it's my honor to have as my guest the Honorable David Narducci, who is one of the 2 town justices in the town of Chautauqua. Judge, it's a pleasure to have you.
Morning. It's
Good morning.
Always a pleasure to be here with you. A couple things before we get started I wanted to mention. I think it was around October 10th we lost one of our finest citizens in the village, is John, otherwise known as Jack Carlson. Jack's done a lot for the village. His family has contributed a great deal. And we wanted to extend the sympathy to his family for their loss and say that he'll be greatly missed. Another issue I heard this morning, kind of shocked me a little bit. I guess everybody's been waiting for this new law that says you cannot use oil-based paint on the exterior of your house anymore. Did you know that?
I didn't.
It's been promulgated under the belief that when you apply the paint, you're releasing all these VOCs, volatile organic compounds, to the atmosphere, which is, of course, destroying our ozone. But the program I was listening to said the manufacturer's recommended procedure for prepping your old latex or your old oil-based paint before you apply the new latex is to put an oil-based primer on it. And I thought to myself, if you can't buy the oil-based paint anymore, how are you going to buy the oil-based primer? I don't understand.
And what difference would it make? It would have the same effect.
Well, I guess, yeah, you're still releasing
Right.
VOCs, but that was, and the last thing I want to mention is if anybody tuned in the hopes of seeing a political ad or political campaigners show up here, I'm sorry, we don't have any this morning, and so don't be too disappointed.
That was my choice.
This morning, we wanted to talk about the new Leanders Lodge. Jim has mentioned the fact that this second part of Leander has come into effect, and to give you a little bit of background, a lot of you may know or may not know that Leander was driven out of an incident that occurred where a child was killed in a motor vehicle accident driven by a parent who was a drunk driver at the time. The law, which the first part kicked in November of last year, I believe it was, stated that if you are now convicted of drunk driving, were in the car at the time as a person under the age of 16, you're now subject to be charged with a felony, Class C, I believe, or Class D felony. If there's a death that results of that child as a result of the drunk driving incident, now you're subject to a B felony. The second part of the law, which kicked in here in August of this year, said that if you are convicted of driving while intoxicated, which is driving with more than 0.08 of 1% or more of alcohol in your blood by weight, the misdemeanor DWI, then you're subject now to the vehicle interlock ignition device that must be installed in your vehicle, plus you're going to be on either probation or a conditional discharge, which is a court probation for a term of at least 6 months. To give you a little background on that, the reason they believe is that if you were drinking and driving once, you're going to try it again, so this way this is to prevent you from doing that. It's a very expensive adder to already an expensive situation, as you know, Jim, if you're convicted of driving while intoxicated. But as we get into the details of the interlock system, the first thing is that if you are convicted or pled guilty or found guilty of the DWI misdemeanor, the court system must process now 16 or 17 additional documents. We don't have enough paperwork as it is, but now we're going to have some more. In there is the condition of probation or court administered conditional discharge, plus other issues where you have to have the interlock device installed. As you start out looking at the program, the individual has no real choice in the matter and no real way to get out of the interlock system. For instance, the interlock system works by you getting into the vehicle, and as you start the car, you have to blow into a device that will register the blood alcohol content of the driver. It cannot be over 0.025% of alcohol in your blood, which is about a half a beer. If you fail the test, the car will not start for a period of about 15 or 20 minutes. It gets you a second try at it. If you succeed and you now drive the vehicle, another 15 or 20 minutes later, it will ask you or demand that you blow into the device again, which we all thought was a real safe thing to have happen while you're trying to drive your car. This is required. And again, if you pass, the vehicle will continue to be able to be driven. This occurs occasionally all through the time you're driving the vehicle. If you fail at any time to pass that breath test, the vehicle will shut down. It gives you a warning so you can pull over, and then the vehicle will shut down and will not start again. Or I believe you get another 5-minute try after that. If it fails that time, then the vehicle locks itself out. You have to have it towed. To go back to square one, when you are first required to have the interlock device installed, you will be given a choice of several installers in the county that you will take your vehicle to. The cost will be between $80 and $100 to have it installed. When the state or the county was looking at the different devices that you were going to make available, there were 3 different levels of devices, and of course our county decided they wanted the best, most expensive device. After the vehicle is installed, after the device is installed, then you pay a monthly rental fee of anywhere between $80 and $100. So during the 6-month period that you're required to have this, you're looking at $600 possible dollars additional to whatever else you're stuck with on your DWI penalties to pay. If the vehicle, for any reason, you fail to pass the BAC test and the vehicle locks out and it's towed to the dealer, then you pay an additional charge to reset and recalibrate the device. And of course, you're now subject to be charged with another misdemeanor for driving with alcohol above the 0.025% level. As we start out in the system and you are convicted of the DWI misdemeanor, first thing that will happen as you are arraigned in court is that your license will be suspended pending prosecution. Now this happens usually anyway with a DWI, but in this case it's really being enforced by the courts. After you have been convicted or pled guilty or whatever, then the court has to determine whether or not you are financially capable to pay for the interlock system, and we have to go through a multi-paged evaluation of your ability to pay. And the questions are like, do you smoke? Well, if you smoke, you can afford the device. If you drive a vehicle, you can afford to pay for the device. So you could be on welfare and still be found financially capable to pay for the device. There's very few people are going to be able to have that device installed at no charge to them. We then go through a determination of whether or not you're going to be on a 6-month supervision by the Chautauqua County Probation Department or the court supervised conditional discharge. If, of course, you're placed on 6-month probation, then the probation department will monitor your progress through that 6-month period. If you're on a court supervised conditional